These teachings, the 14th and final book of judgments of courts. We are still in the laws of witnesses and how they are to be dealt with in a Jewish court. We're in chapter 14. So, whenever a witness is disqualified from testifying on behalf of a colleague because he is married to the witness relative, so witnesses relatives. So we learned previously, a witness is disqualified if they have a relationship, and what that relationship means and how close that relationship is. We spoke about in yesterday's class, or in yesterday's teachings, rather. So whatever that definition is, being a relative, if that relative's wife dies, sorry, 1 second. So if that, so remember, he is a relative here through marriage, right? So if the relatives, so dies or divorces, so they're no longer connected. Even if she left him sons, he's considered to have been released from any connection as acceptable as a witness. Right, so if Reuven is married to Rachel, and Rachel has a sister Leah that's married and has children, but she passes away. So the connection to that family is because the two sisters. But because she passes away, so he's released from that connection, which just means that that person is acceptable to be a witness. Okay. When a person knew of evidence concerning a colleague before he becomes his son-in-law, and then became his son-in-law, he's not acceptable. So let's say you had evidence, right? Concerning and now the plaintiff, your son, becomes your son-in-law. So he can't now, because it's your son-in-law. That's a relative. So you cannot now, even though the evidence you had, the witnessing you had before he was your son-in-law. The same law applies if the person was in control of his senses and then became deaf, mute, and able to see, or was able to see and became blind, even though he was aware of the measure of land concerning which he testifies, and he can define its boundaries, or was intellectually and emotionally sound, and then lost his control of his faculties. So over here, what happened? Right, another is someone who loses their faculties or becomes deaf mute, right? Now he was okay when he was the witness of something, right? He knew the boundaries of this territory that belonged, right? And the plaintiff is claiming that someone stole land from him by moving the boundary over land, whatever it is, right? But then he became either deaf mute or became blind, or became blind, right? Whatever the so similarly, he would not be able to give the evidence because at that time they're disqualified, even though the awareness of what they know as a witness was before they became, you know, losing their, you know, sound mind and so on, right? If by contrast, a person knew evidence concerning a colleague before he became a son-in-law, and then the colleague's daughter died, the witness is acceptable. Um, so his daughter died. He's no longer a son-in-law, meaning in a legal sense, right? Doesn't mean he might not treat him that way, because his connection is only because he married his daughter. So now he could be a witness. Similar laws apply if a person was in control of his senses, became deaf mute, and then regained control of his senses, was intellectually and emotionally sound, lost control of his faculties, and then regained control of them, or was able to see, became blind, and regained his sight. So once he regains it, he's okay. The general principle is whenever a person is an acceptable witness at the initial and final stages, he's acceptable, even though in the interim he was not acceptable as a witness. If, however, initially he is unacceptable, even though ultimately he would be acceptable, he's disqualified, right? Therefore, when a person is aware of evidence as a child, it is of no consequence for him to testify with regard to it when he attains majority, because as a child, he's not able to be a witness. Let's say he was underage, right? And then, half a year later, he became of age, and now he could testify. But because when he was the witness, he was unacceptable as a witness because he was underage, right? So now the fact that in court he's testifying when he's of age doesn't matter, because when at the beginning, he was unacceptable. Okay. I'd love to continue, but I gotta go. All right.